Assembly Number 2176A, Calendars 93, Ms. Solange. An act to amend the civil rights law and the judiciary law.
An explanation is requested, Ms. Solange.
Yes, Mr. Speaker. Access to our court system is vital for all persons in New York State. This bill would help assure access to important court proceedings. The bill would provide individuals from warrantless civil arrest while going to, remaining at, and returning from a court proceeding, where such person is a party or potential witness, or a family member, or a household member of a party or a potential witness. However, such an arrest should be permissible if it is supported by a judicial warrant or judicial order authorizing such arrest. This bill reflects a long-standing protection in the civil rights law against civil arrest for individuals going to, remaining at, and returning from court for certain purposes, including serving as a witness. The bill, which has gathered strong support from both immigration reform advocates and the community of legal practitioners, will help promote the integrity of our court system in New York State and uphold all persons' right to access the court system. Yes,
Will you
Mr. Speaker.
yield? Ms. Solange, will you yield?
Yes.
Ms. Solange yields.
Thank you, Ms. Solange. So I just have a couple questions. And I think what I really want to get to is the breadth of individuals who could be covered by this piece of legislation. So under our current law, we already protect the witness going to court, do we not?
Yes, Mr. Speaker.
Okay, so this expansion then under this bill protects a family member, and it doesn't define family members, so I don't know how far that goes. If it could be a cousin, an aunt, an uncle, a twice removed, we don't know how we're defining family, do we? Or do you have that defined somewhere in the bill?
So, we know that judicial process is quite complex. At times individuals receive a ticket or a witness, and it's sometimes intimidating to go alone. So we should have no objections as to who is accompanying a potential witness or defendant. We should allow people to be able to bring whomever they want to come to court, either it's for moral support or for advice. It should be permissible. And so we don't speak to that in the bill because we want people to be comfortable with whom they want to go to court with. Because at the end of the day, we want to ensure that the judicial process is happening here in New York State. We want people to go to court. We want people to be model citizens.
Okay, so what you're saying really is that in addition to a family member or a household member or a potential witness, it really should be anybody who's coming into court should not have to fear arrest. Is that your position? That's more even than what the bill says.
So this bill just wants to ensure that the federal enforcement agents or officers have a judicial warrant, that they abide by the Fourth Amendment, which requires judicial warrants or a notice from a judicial magistrate. And that's all we're asking for. It's very simple. I think our forefathers believed in judicial warrants and, all of our legislators out there. So that's what this says, that, officers can come, but we just want a judicial warrant when they're talking about going to the courthouses or arresting someone going to court or leaving court.
Okay. So what about just a spectator who's not a family member or who isn't a household member? I mean, really what you're saying is really anybody in the court system should be immune unless there is a judicial warrant, as you said.
So you were talking about having this in good faith, and we're talking about the person accompanying either a witness or a person going to court. That's what the bill is speaking to, and we're speaking about good faith.
Okay. So under the process that's laid out in the bill, I think there were some amendments to the bill made last year, it looks like. So can you describe if you are a representative of a law enforcement agency who is in their official capacity, they enter a New York State courthouse intending to observe an individual or take that individual into custody, to walk us through the process of what that individual would need to do.
We're allowing federal agents to come into the courthouse. It's just the arrest. There's a privilege of arrest clause law that we have in statute, the Civil Rights Law, Section 25, that says that civil arrests cannot happen. And so, individuals are welcome to our courthouses. We want to send a loud, clear message that our courthouses are open for all. Because as you know, Lady Justice is blind, regardless of your race, your income, your nationality, or your immigration status. The courts are open to all.
Right, and I wasn't suggesting that the person couldn't enter the courthouse. I'm saying, how could they? What's the process for that individual, that representative of a law enforcement agency who wants to effectuate a judicial warrant when they enter the courtroom? What do they have to do?
So on April 17, 2019, the Office of Court Administration actually put out a directive that gives a rundown of all the process that needs to be done. It's quite a lengthy document. You want me to read it to you?
No, I guess what's sufficient. Let me see if I can maybe just quickly summarize it. Maybe you could just confirm
And
whether
the
I got
language
it right.
is verbatim, is somewhat verbatim in the language of the bill.
Yeah, I don't think you need to read any large section. It looks as though the individual has got to, when they come into the courthouse, they have to present to a court officer a copy of the judicial warrant. Is that correct?
Yes, they have to present a copy. They have to first identify themselves.
Yeah.
Then they have to present the judicial warrant if they were. So are you talking about the process of the law enforcement agent just coming in to the courthouse, or the process of doing a civil arrest?
Doing a civil arrest is where I was going with that.
So once again, they have to identify themselves. They have to provide the documentation. And then, everyone works together to facilitate the process.
Well, once the court officer gets the warrant, then the court officer's got to present it to the judge there to review it, and then or the court attorney to promptly review it and determine, I guess, to see if it's valid, if it can be executed. And then it says that only in extraordinary circumstances may an arrest be made in the courtroom absent the leave of court, and that and you can't do it without a judicial warrant or judicial order authorizing the arrest.
Let me
Did I summarize that all right?
Pardon, sir. Let me just clarify. There's administrative warrant. An administrative warrant in immigration matters is an agency-issued arrest request that a person to be taken into custody for alleged violations of federal law. So administrative warrant is requested from the federal agency, whereas a judicial warrant is signed by a judge, which means that there needs to be probable cause, that there's a reason. And so we're just preventing federal agents from using an administrative interoffice document to try to do civil arrest in our courthouses, because we've seen that it's proof positive that at times federal agents come into the courthouses and disrupt the proceedings. If they don't get what they want, they cause disruptions. For example, in Yonkers in November of 2019, a federal agent was able to arrest and actually kick the door of the courthouse, which happened to be made of glass, and break the glass of the courthouse. And this is solidified by a police report. So, we're talking about ensuring that we have peace in our courthouse, that people can get through the judicial process and send a message that our courts are open for all.
So, yes, and so we've talked about the arrest, the situation where the arrest is being effectuated in the courthouse itself, but your bill actually goes further than that. It gives protections to that family member. We've decided that's not really even defined what family member is, or household member. They can't be, under your bill, arrested on their way to court, or while they're at court, or when they're on their way home from court. Is that correct?
Yes, it's correct. It's actually 100-year-old law, and I'm trying to find the documentation. Just give me one moment, please.
Well,
So during
your bill isn't that old, though.
No. But
Right.
the English courts in the late 1800s repeatedly recognized a common law privilege against civil arrest for anyone presented in the courthouse or on the grounds or coming to and from court. But it gets even better. During the 19th century and early 20th century, American courts, including the New York State Court as well as the U.S. Supreme Court, confirmed that this privilege was a part of the law. So there's actually a privilege of not getting arrested, going to court or leaving court or being at court.
And
so
as
this
we
is
I'm sorry.
Yeah.
And as we discussed at the beginning, we don't we don't challenge the existence of that. We know that for very many years, I didn't realize it was that long, but for very many years, we have protected the witness who is coming into court. But again,
And
your bill broadens the scope of the individuals who are protected
so
under that long-standing
only
rule.
subpoena witnesses are protected. But again, we are trying to preserve our judicial process. We want everyone, regardless of their immigration status, to feel comfortable to go to court. You know, just like I said before, justice is blind. Everyone has a right to due process. Everyone has a right to go to court.
Okay. How long
so-
after the individual who's the household member or a family member, how long after they return coming home from court may they then be arrested?
So, you know, we want individuals to be able to be comfortable to go to court. Women who are assaulted should be able to get an order of protection. With COVID-19, we're going to see mass evictions, and many of those individuals are mixed status families. So what that means is that some of them are, you know, non-citizens, asylum holders, undocumented, and others are actually U.S. citizens. So we want to ensure that every single person has a right to go to court and feels comfortable. This bill is sending a message that everyone can go to court without feeling that they're going to get arrested or deported, because that impedes, it puts a chilling effect on our court system. And I know that if a witness, maybe they happen to be a non-citizen, a witness wants to point out my accuser and testify, but is afraid to go to do that, that's a travesty on justice. And that hurts the whole judicial process.
Very good. So my question is, so you've got a person who is undocumented and they have gone to court, they have been there for, as you said earlier, maybe moral support, or they're spectating, or they're a member of the family, the household, and then they leave the courthouse and they go back to wherever. How long after that can they then be arrested by law enforcement? Does your bill speak to that?
It's clearly stated in the language. It's only to and from. It's very simple. To and from in good faith.
But where are they going back to? Their residence or their place of work,
Leaving
or
to and from court. So if whether they're coming from and wherever they're going.
Okay. All right. Well, thank you very much for your answers to my questions, Mr. Speaker, on the bill.
On the bill, ma'am.
So I tried to bring out in my questioning that we have no objection to the concept of the witness being protected and has been for many years. I think the problem with this bill is that it greatly expands the scope of the individuals who are protected. I understand and greatly respect the sponsors' explained rationale for the bill. I think, though, that during our conversation and on debate, it appeared that the bill was even being expanded more beyond the bill language itself, just during the debate, to be really just somebody who's spectating at a court proceeding. And I don't know that an individual should be entitled to those types of broad protections going to, staying at, and leaving a court proceeding simply because they are a mere spectator. So for those reasons, I'll be voting in the negative. Thank you.
Thank you. Mr. Goodell.
Thank you, Mr. Speaker. Would the sponsor yield?
Solange, will you yield?
Yes.
Thank you very much. From your comments, it appeared that you are particularly concerned about the situation where a non-witness, non-party to a court proceeding, a member of the household, for example, might be stopped going to or from court by an immigration official and taken into custody because they're here illegally or they're lacking documentation. Was that really one of your main concerns on this bill?
I'm sorry. Could you elaborate on your question?
Sure. Was your main concern on this bill that an immigration official might execute a non-judicial civil arrest of an undocumented or an immigrant who's here without legal authorization while that person is going as a member of the household to watch a court proceeding. Was that really the thrust of your concern?
My concern, and we have countless DAs from Albany, from New York City, from Long Island, from across the country, who have expressed concern. Even chief judges who could express concern that they're not able to facilitate the judicial process. And so the judicial process isn't just going to court. It's also going to the clerk's office to hand in paperwork. It's anything dealing with court operations. And so my concern is that the court operations were being impeded by a third party, especially a federal third party. And I don't believe in state violence against us, and so I want to stand up and push back and ensure that our judicial process is protected, our state judicial process.
Certainly, and I appreciate that desire, but the concept of a civil arrest is not very common. There's only a few situations where civil arrests occur, right? One might be, for example, a violation of a court order where you have an order of contempt. That's a civil arrest, right? Immigration officials, they have the right to make a civil arrest, right? With or without a judicial order. Are there other examples of civil arrests?
So I'm just going to take a quote from the federal judge that actually put out a decision, thank you, a decision. And he said, immigration detention has arisen to a new inclusive form of civil arrest. And that's straight from a federal judge.
But in terms of the context, so we understand what we're talking about. Civil arrests are typically orders of contempt.
And individuals
violation, maybe a violation of an order of protection, although that can be criminal as well. And immigration, is that the three? I mean, are there other categories, other types of civil arrests that you're concerned about?
So as I said before, this is a old standing privilege, and this is something that's always been protected. We don't support civil arrest in the courthouse. So, and we have to be careful about painting all immigrants as criminals and public safety threats, and it's racist and dangerous. In a country, everyone, including immigrants, have rights, including the right to access court, to defend themselves in court, and to seek legal representation of the court. So, we have to not look at the individual nuances, but look at the language. It's civil arrest. There's a privilege from civil arrest that's within 100 years of Civil Rights Law, Section 25. And I can read it to you if you like.
No, I'm familiar with that. So maybe you could help me just understand this. Let's say that a relative of a witness or a party to the court is stopped, or someone in the same household is stopped going to or from court, and they're stopped by an immigration officer. Who wants to take them into custody because they're here illegally or without documentation. And the person says, oh, wait a minute, under this new bill, I'm protected from civil arrest. What should the officer do? Should he just take their word, or can he detain them temporarily while trying to verify whether they're actually going to or from a court proceeding? How would that work?
So I would hope that the federal, there's been a directive, there's a federal decision. ICE officers are very familiar with the process, or federal officers are very familiar with the process. So if someone says that they're going to court, that individual is protected. But they can get them, or ascertain them if they get a judicial warrant. And I would hope that they would walk around and obtain a judicial warrant if they would like to arrest someone.
Well, keep in mind, under the current protection covers anyone who's a witness or anyone who's a party. And that's very easy to document, because if you're a witness, you have a subpoena. And so, if you got stopped, for example, coming or going, you pull out a subpoena and say, officer, here's a copy of the subpoena. As you can see, I'm protected. Or if you're a party, of course, you can bring out a copy of the summons or complaint or whatever the court documentation. How do you document that you are going to or from court?
So I want
when you are, just let me finish the question. Sure. When you live in the same household, or you're a relative, but not a party, particularly if you are not traveling with the party. Let's say you're going to court in a separate vehicle or on a subway in a separate, you're meeting them there. How do they establish that they are going to or from court so that the immigration officer is not arrested as they could be under your language, right? An improper stop would subject the immigration officer, federal officer, to arrest for false imprisonment, right? So how do they document that this member of the household or this relative, who may not even be in the same household, falls within the scope of this statute?
So federal officers, immigration officers, are using our courthouses as traps. So they're purposely looking at the court dockets. They're looking at names. They're cross-referencing it with their list and identifying who people who are immigrants. So they're using our state data and information as a means to be able to, arrest individuals, which only makes the consequences that, the consequence being is that that person is not able to go to court, which hurts our judicial process. So just to explain, so to go case by case basis, it makes it difficult because there's different nuances. Because an individual can have a conversation. It seems like these federal agents are following the person. If they were to, it seems from what you're saying from your example. So it's very difficult because every situation is very different. But let me read please let me read the civil rights law really quick. I'll read the last sentence. Really, an arrest made contrary to the provision of the section is absolute and voided, and is contempt of court, if any, from which the subpoena was issued or by which the witness was directed to attend. So that's current law. So that's the exact current law. So it's only the people who are subpoenaed. So we're not providing protections for New Yorkers.
So my question again, I apologize, and I apologize for almost interrupting you.
Yeah.
My question was very specific. I understand all the theory that you mentioned, and I appreciate that. My question is very specific. What documentation would be shown to a federal official to indicate that a person who doesn't even live in the same household, A, is related to somebody in the court, and B, is on their way to or from the court? What documentation can the person who's stopped, who's unrelated to anyone in the courthouse, living in the same household, or alternatively is related but doesn't even live in the same house, what documentation can they show the immigration official so that the immigration official doesn't run the risk of being arrested for false imprisonment?
So
what documentation? That's the question. What documentation will they have?
So you can have a ticket, court documentation.
Well, that would be available to the witness or a party. I'm talking about a non-witness, non-party, a relative who lives in some other house. What documentation would they have with them or could have with them to document that they're coming to be a spectator at some other court action?
So simply, if the individual says, "I am with so-and-so person," that person also produces
and
some
if they're traveling
documentation.
Separately to the court, what documentation?
Now you're bringing in nuances. What if the person's jumping down from a parachute? We can't provide these examples. I trust federal agents to be able to ascertain and be able to communicate and be able to make an arrest and make a solid lawful arrest. And if they're trying to wiggle through loopholes and such, it just really is a defamation on justice.
Thank you very much,
So,
and I appreciate.
I was just gonna.
Oh, I'm sorry. I didn't mean to interrupt you.
I'm so passionate, so I just.
Yes, indeed.
And also, in the directive, so in January of 2017, the federal government did an executive order, and also there was an impending memo done and circulated amongst federal officials saying that the arrests have to be lawful. And lawful means to ensure that faithful execution of the immigration laws of the United States are done in such a way. So, even within documentation, they want to employ all lawful means. And so I would hope that these law enforcement agents are, dotting their I's and crossing their T's and not going with hypotheticals or maybe, these individuals know what they're doing. By identifying and going through our court dockets and waiting for individuals coming to and from court, they know exactly what they're doing. And so all that we're saying is that we need to protect our court system. We need to protect all New Yorkers, regardless of immigration status, and allow them to go to court. They should not be using our courthouse as trap houses.
Thank you very much. I appreciate your passion and I appreciate your answers as well. On the bill, Mr. Speaker.
On the bill, Mr. Goodell.
As my colleague noted, for well over 100 years, New York, along with most of the nation, has recognized that a witness or a party to a lawsuit is immune from civil arrest while traveling to or from the court. That's the current law. If you're a party or if you're a witness, you're exempt from civil arrest. What this bill says is if you're a spectator, not a party, not a witness, but a spectator that's related or might even live in the same household, if you're a spectator, then you are also protected. And it turns around and it says, if you are a federal immigration official and you stop and execute a civil arrest on one of these spectators, you could be arrested for false imprisonment or be facing a fine. And so here we have a law that subjects federal law enforcement officials who are carrying out federal law to being arrested in New York State if they arrest a spectator who claims they're coming or going to watch some legal proceeding involving a member of their household or a relative. Keep in mind that we are creating an impossible situation for those federal law enforcement officials to verify that the person is actually going to or coming from a court proceeding, because unlike a party or unlike a witness, there's no subpoena to this spectator. They're not named in the proceeding, and they would have no documentation. The current law strikes the right balance. The current law says if you are a party or you are a witness, you are exempt from civil arrest. This law says we are now making spectators exempt from civil arrest if they happen to be related to anyone in the court or live in the same household. That goes too far, and it makes federal law enforcement officers subject to criminal prosecution for carrying out their duties to enforce federal law. That's an inappropriate change in the way we deal between those who are here illegally and those who are intent on enforcing law. Thank you, sir.
Ms. People-Stokes.
Thank you, Mr. Speaker. Actually, rise to just thank the sponsor for this legislation. This is a really difficult thing to do when there's so many within our house and within our society who don't think that people who don't yet have their American citizenship should have the same protections as everyone else. I came from a family that wasn't necessarily immigrating to America, but was forced here. I understand that there are a lot of people who come to America by their own will And sometimes you really do need to have that person that can help you understand what's going on through the court proceedings that you have to go through, that will have the same experience you've had, that has a level of empathy for you, that can help you speak and understand the language. Um, most Americans speak one language, but most people who come as immigrants speak more than one language. All of our court systems are not necessarily at a place where they can articulate and or handle. And so, what is wrong with bringing someone with you who can support you during the process, and then them not have to worry about being arrested on their way home? Now, if somebody has done something that they need to be, picked up or prosecuted for in the future, that's not what this bill is talking about. This bill is talking about going to and from a process that happens within our judicial court systems. So again, I want to commend the sponsor, and I hope that colleagues will have an open mind when making their decision about whether or not this legislation moves forward. I, for one, hope that it does. It's important work, and it's work that needs to be done, particularly in 2020.
Mr. Barron.
Thank you very much, Speaker. This is always very interesting to me, how we just forget history. The people who are coming here now, whether they're from Mexico or from the Caribbean or from Africa, the indigenous people of this land were African and so-called Indians. And matter of fact, if you might remember, Texas seceded from Mexico and became a country of its own first. Then they joined the United States. You done ripped off a part of Mexico and made Texas a state. Talking about a spectator, my colleague, you live in a bubble. You are the spectator. You came here from other places and took land from people. Your ancestors did this. So who is the real spectator? I think this bill is good. Immigrants contribute billions of dollars to this economy. So-called immigrants, some even fighting wars. But yet, the only thing this bill is saying, you can't use the courts to entrap immigrants. You can't do that, whether they're spectators in the courtroom or not. ICE, under the Obama administration, deported millions, and they continue to do that. They terrorize immigrants. They are racist, and they should be dismantled. But this bill is simply saying, no, you cannot entrap immigrants in the court system. You can't hang around the court system preying on them, P-R-E-Y, not P-R-A-Y, preying on them so you can what? Make America great again? Keep America as white as possible? Avoid the browning of America? This is a good bill. This is a simple bill. This is a bill that ain't calling for no revolution. It's just calling for protection of immigrants when they have to go to court. And yes, even if they're spectators, to support a family member. Good bill, sponsor. We should support this. This is a no-brainer. It's simple. And it's interesting when you gotta fight for such simple, no-brainer bills. You would think people live in some bubble, that they don't know what's going on outside of their little bubble. But we need to get hip to reality. America is changing. And there's nothing you can do about it. No kind of suppressive laws, no kind of agency like ICE is going to stop the browning of America. So I say that we should appreciate immigrants. They contribute to the cultural richness of this country, to the intellectual capacity of this country. They contribute to hard work and labor in this country. And this bill merely says, if they have to go to court, let their family come and sit and be supportive of them without being in some trap set up by the racist ICE that needs to be dismantled. When the European immigrants came, Irish, Polish, Jewish, Germans, Italians, yes, they were discriminated against because the white Anglo-Saxon Protestants from England did that. But they didn't get treated like this. When the color of immigration changed, don't even want their families to go to court with them. Absurd. I applaud the sponsor. Great bill. Let's do the right thing, Assembly, and pass this bill. I vote in the affirmative.
Ms. Cruz.
Thank you, Mr. Speaker, on the bill.
On the bill, ma'am.
So I have a couple of rhetoric questions. I'd like to know who these spectators that are going to court just for fun are, because as a former legal services attorney, I can tell you that the only people who are willingly going to court are family members accompanying the folks who have to go to court, the folks who have to go to court, and us, the lawyers, and the witnesses. And the idea that there could be acceptance to spectator arrest almost strikes me as the idea that it would be okay to conduct racial profiling. Because how would ICE know that a spectator is someone who should be arrested? And then that gets us into the question of ICE warrants are civil in nature. ICE warrants are not authorizing a criminal arrest. And the promise that this country gave us when many of us have come, who come from other countries, and those of us who came undocumented and fleeing what are basically lawless countries and other places, is that here in the United States, we have a constitution. That constitution protects us regardless of the color of our skin or the status that we have. And that constitution doesn't simply stop because of how we look or because a federal agency wants to step into a courtroom and, as Mr. Barron said, entrap us. And so I want to thank the sponsor of this legislation because it is a long time coming. How do you promise a witness? How do you promise a human trafficking victim? And I mention a human trafficking victim because back in June 16th of 2017, ICE attempted the arrest of a human trafficking survivor at human trafficking court in Queens. How do you promise any of these folks that when they step into court, they'll have their day in court, that they'll be protected, that the promise of this nation to keep them safe will remain so when they step into the one place that it should absolutely be clear exists? It doesn't happen right now. And unless we pass this bill, we are going to continue to see the behavior of ICE get worse. The behavior of federal agencies get worse, because if you have been paying attention to the news, you saw what happened in Portland, and it is about to start happening in New York. And we need to make sure that we protect victims, that we protect witnesses, that we protect lawyers, and that we protect the family members who are simply looking to give some support to the people who are in court, seeking justice, because that's what our courts have promised us. And so the idea that we would even have to ask for a bill that basically says what a judge has already decided should be the law of the land is quite frankly insane. I am going to be voting in the affirmative, and I'm asking my colleagues to do the same, because we got elected to protect the Constitution of this country and our state. And we have a rogue federal agency, a rogue administration, trying to find every and which way to keep our people down, to arrest them, to deport them, to take them away from the only families and the only country they have known. And so I want to reiterate a couple of things before I end. ICE does not have the ability to conduct criminal arrests. That is why we're asking that they go and get an order from a judge. The Constitution protects us no matter what status we have. There is a notion of innocent until proven guilty that many of us went to law school and have been fighting our entire lives for. And if you allow ICE, an agency, to come into a courthouse and arrest someone before they've even had the opportunity to have their day in court, or because they're engaging in racial profiling, because let's get it clear, if they're arresting someone because they're a spectator, that is racial profiling, because how the heck do you know that someone is an undocumented immigrant simply by looking at them? I can guarantee you that nobody knew it about me until I said it. And so I am asking that we as legislators uphold the Constitution of this country and protect the people who elected us to protect them. Because I want to remind everyone, we didn't get elected just to protect the people who vote for us. We got elected to protect every single person that lives in our district. And I'll be voting in the affirmative. Thank you.
Ms. Glick.
Thank you, Mr. Speaker. I want to congratulate the sponsor for bringing this forward. Essentially, ICE is operating with interagency or interoffice memos, and that's how they proceed. And they come to the courthouse, undermining the ability of all of us to get justice. If somebody has been a witness of a crime, they may be a witness of a crime that has been committed against any one of us, and we may depend upon them in order to have the perpetrator identified and prosecuted. Undermining that isn't undermining it for a particular group of people, undocumented people. It is undermining it for everyone. The federal government has brought a strange new notion of having unidentified federal officers appearing in the cities from Washington, D.C. first, now to Portland, and we'll see where else. This is disgraceful. It is frightening. It reminds me and my history, my family history, of the brown shirts of the 30s. Unidentified officers showing up and taking people off the street. So it makes sense that we ensure that someone who is a federal agent, an ICE agent, or any other agent has to have a warrant, not a memo, which is essentially what ICE warrants are. They're an administrative warrant. So to me, it's an interoffice memo identifying someone and then trawling the courthouses to try to find people does not make any of us safer. So I applaud this measure. I thank the sponsor for bringing it forward. It is a measure of protection for all of us, because you don't know who you may need to depend upon to come forward in a court action on your behalf, and making certain that the courts are sacrosanct is in everybody's interest. So thank you, Mr. Speaker, and very much thanking Member Solange for bringing this forward. Since I'm not explaining my vote, I can mention her name.
Thank you, ma'am. Mr. Epstein.
On the bill, Mr. Speaker.
On the bill, sir.
Thank you. I also want to applaud the sponsor for her leadership on this important issue. As some of my colleagues just said, I'm a lawyer. I've been to court hundreds, if not thousands of times. and I see how the court system is used to continue injustice in our society. And racial profiling, unfortunately, is part of the system of our society we live in. ICE just wants to put that on steroids. They want to be able to continue to go into court and target people based on only thing I can think of is their race, and to try to get what they believe is undocumented people out of court. These quote people are people who are there seeking justice from the system. These could be, as someone said, they might be spectators, but spectators are not that. Spectators are potential witnesses. They are moral support for people, maybe someone who's a domestic violence survivor. They could be a translator. They can be a trusted friend. The people who go to court are an integral part of our court system. And if we believe that the court system should be open to all, we need to ensure that it is open to all. We live in a system that's racist. We live in a system that's unjust. We live in a system, as we see every day by what was happening across this country and what we've seen from the Black Lives Matter movement, that we need a better way to approach injustice in the world. This is one step forward. This is how we make the court system a little fairer. This is how we ensure that people who are going there to seek some level of grievance have the ability to do that without the threat of deportation or arrest from ICE. ICE is deeply troubled and deeply problematic, and we should abolish it. But until that day, that we don't have a system where people go rogue all the time and attack people based on their race and potentially rip families apart who have been here for decades, until we have that day, we need these important victories. And Assemblymember Szilagyi, I want to applaud your effort here. I encourage all my colleagues to vote in favor of this bill. I know I'll be voting in favor of it as well. Thank you.
Ms. Simon.
Thank you, Mr. Speaker, on the bill.
On the bill, ma'am.
I too want to commend Ms. Solange for for this bill, for arguing it so eloquently. ICE is laying in wait outside our courthouses. That's what they're doing. They're just laying in wait. They are there to terrorize anyone who ICE may have profiled as being undocumented and subject to deportation. They are doing it by using false documentation. They are not using proper process. And they are there to simply frighten people. They're there to frighten the people who have a matter before court, or someone who might be assisting someone or just supporting someone, who might be translating, all of the various permutations of why anybody would go to court to be there for someone, to just support them in any way. And these tactics have a very dark past and a very dark history. We know that history, and that history should not be happening. That should not be repeating in the United States of America, and it sure as heck shouldn't be happening in New York State. And so I encourage all my colleagues to vote for this. Again, I want to commend the sponsor, and I will be voting in the affirmative. Thank you.
Thank you so very much. Read the last section.
This act shall take effect immediately.
Clerk will record the vote on calendar 93. This is a party vote. Any member wishing to be recorded as an exception to the conference position is reminded to contact the majority or minority leader at the number previously provided. Mr. Goodell.
Thank you, sir. The Republican conference will be voting no on this bill in general, but any Republican members that would like to vote yes, please contact my minority leader's office as quickly as possible. Thank you, sir.
So noted. Ms. Peoples-Stokes.
Thank you, Mr. Speaker. This will be a party vote in the affirmative. Members wishing or desiring to vote no on this piece of legislation should contact the majority leader's office, and we will make sure your vote is properly recorded.
Thank you, ma'am. So noted. Mr. Pichardo to explain his vote.
Thank you, Mr. Speaker, for allowing me to take a pause and explain my vote. First of all, I want to commend the sponsor on this piece of legislation, and I want to make sure that it's clear to all of my colleagues that regardless of your documentation status, everyone deserves equal protection under the law. And when the law falls and is heavy-handed in its enforcement, it creates a counterproductive scenario. And more importantly, it makes law enforcement's jobs harder because you will have less cooperative communities, and the fact that people will have less of a likelihood or even want to cooperate with law enforcement authorities. I think the idea of making sure that people feel safe to not only interact with the judicial system, but also feel that they are protected by their government in any circumstance or any other situation. So I commend the sponsor for this piece of legislation. I commend my colleagues for voting in the affirmative, and I encourage everybody to do the same, and I will be voting in the affirmative.
Mr. Pichardo in the affirmative. Mr. Rodriguez.
Thank you, Mr. Speaker, for the opportunity to explain my vote. And I just want to commend the sponsor for this important piece of legislation. It's important, certainly as representatives of the Latino and Latinx community, but also for anybody who is, looking to go to court to have their day and to resolve matters, to understand and know that they are not going to be further preyed upon or victimized by law enforcement as a result of showing up to those proceedings and looking to get their fair day in court. So I think it's important for us to send this message that, certain places, should not be target areas for either the federal government or any other agency, to further victimize people, and also must keep in mind the sanctity of the judicial process and the system for all its flaws, but making sure that people can access it with the same level of expectation, in terms of what they're expected to do when they have to go to their day in court or to their appointment, that they have the same protections and are not victimized as a result. So I will be voting and supporting this legislation. I encourage my colleagues to do the same.
Mr. Rodriguez in the affirmative. Ms. Solange.
Thank you, Mr. Speaker. To explain my vote, a victim is not a party until they file documentation with the clerk. We have DAs from across New York State, Albany, Bronx, New York County, Nassau County, Westchester, who wrote a letter to legislative leaders saying, as ICE agents become an increasing regular presence in our courthouses, there is a detrimental effect on the ability to investigate and prosecute crimes. A woman who has been assaulted needs to be able to testify against her abuser. A tenant serving with an eviction notice needs to be able to defend the case. A consumer who paid money but did not receive the product should be able to go to court. We're New York State. We have sent a signal, and with this bill, we send a signal that our courthouses are open for all, and that the judicial process can be done, and that when you go to court, you are going to be safe. So with the passage of this bill in the Assembly and Senate, we send a loud message to our community that you are here to stay. I'd like to thank IDP, who has documented the 1,700% increase of federal agents arresting people to and from courthouses, New York Immigration Coalition, the countless legal aid lawyers who have said that this piece of legislation needs to pass the legislative process. I thank them all. I thank everyone who championed this bill, all my colleagues, and Speaker Hasty for believing that we need to make sure that our judicial process is open to all. Thank you, Mr. Speaker, and I vote in the affirmative.
Ms. Solange in the affirmative. Ms. De La Rosa.
Thank you, Mr. Speaker, for the opportunity to explain my vote. I simply want to uplift my colleague for all her work in defending this important piece of legislation. As has been said time and time again, this is about allowing access to justice, and our court should be the place where access is held and where people have the ability to go and defend their cases and watch cases and be there for their relatives as they defend their innocence. So thank you to my colleague, and I vote in the affirmative.
Ms. De La Rosa in the affirmative.
Mr. Speaker, we do have one of our colleagues, Mr. Santa Barbara, who would like to be recorded in the negative.
Thank you. So noted.
And then back to you for the next three.
Are there any other votes?
And then back to Crystal for the next three. Okay, good.
Announce the results.
Ayes 98, noes 43.
16 and 18.
The bill is passed.